Do they react too quickly? Do they not take the amount of time that they should take? I mean, I understand that you've already talked about underinsurance, and I understand that you've talked about replacement value, and I understand that you've talked about that. That's all great for going down the road. But for those who have had the loss, they've got what they've got, what's the biggest mistake that they make?
Relying on the opinions of people who don't know what they're talking about.
Very good. I love it. I just absolutely love it. What does that mean?
One of the misconceptions that is very common is that people will assume that if you have to file a lawsuit to get the insurance company to stop lowballing and start doing what it's supposed to do, that it's going to drag the thing out. You're going to have to pay lawyers and legal fees. You're going to have all of these other expenses, and it's going to prolong the whole process. The truth of the matter is, I mean, from my experience, it is that you actually put things on the fast track if you have to file a lawsuit. The reason is because back home in the insurance company, they bump it up from Mr. Claims Adjuster from Bogalusa. He's no longer going to handle the decisions in the case. All of a sudden, their legal department gets involved. And the legal department understands very well what California law is, and this is something to remember. If an insurance company engages in bad faith conduct, which means simply unfair claims handling practices, if there's anything that they do, anything that is unfair to the consumer, they are guilty of bad faith in the state of California. What does that mean? That means that the insurance company is responsible for all of your damages, not just the policy benefits. So if you have a $500,000 loss and the insurance company engages in protracted delay or under-settlement tactics or uses fraudulent practices to misstate what the policy provisions provide and so on and so forth, the insurance company is responsible for paying your attorney fees. So it will cost you nothing to take on the insurance company if they're guilty of bad faith conduct. That's number one.
Wow.
Number two, you're entitled to recover for any emotional distress caused by delay. And a lot of people don't realize what kind of problems can result from that. But when you're living in a hotel or in some place that you would like to get out of and get back into your house again, and the insurance company tries to use the leverage of delay in order to get you to undersell your claim, that causes emotional distress. It causes strain on relationships and marriages. Sometimes it causes people to have to miss payments that they owe on various items that they are purchasing. Mm-hmm. It causes you to have to endure expenses that you otherwise wouldn't have. All of that is the responsibility of the insurance company. And plus, they're responsible for any emotional distress that you suffer as a result of that. And we're not talking about making up stuff. We're not talking about exaggeration. You never, ever want to exaggerate anything with an insurance company because it'll come back and haunt you.
Oh, boy.
But if you're telling the truth about what it is that's going on and the insurance company ignores you, they're going to be responsible for that, not you. The last point on a bad faith case is that the insurance company, if they're guilty of, this is technical language, but if they're guilty of malice, fraud, or oppression, as those terms are defined in under California law, and it's clear and convincing that the insurance company is engaged in that, not just speculation, but it's obvious, which often it is obvious because they put it in writing. So, there's no question about it. But if they're guilty of that, then the insurance company can be responsible for punitive damages or exemplary damages as well. So the insurance company claims people don't know this necessarily, but their lawyers know it. And when you file a bad faith lawsuit, they're going to take a look at that file, and they're going to move things along much more quickly than the claims department ever would if they see this coming.
Often it comes down to appraisal, mediation, and arbitration. What should we know about that, Ray?
Well, I like the idea of mediation. In fact, there are many judges. I'll give you an example. A judge by the name of Chiantelli in San Francisco works with First Mediation. He was the former presiding judge of the San Francisco Superior Court. He is a very knowledgeable, extremely persuasive individual. He has persuaded me more than once about his point of view on things. So I speak with experience.
Mm-hmm.
But somebody like Judge Chiantelli can take a look at the side, put one side in one room, the other side in the other room, and go back and forth and hammer out a solution that is not simply a compromise, but is a substantive decision that is being made. And mediation is not binding. It's not like arbitration. A mediator is a facilitator, and his job is to persuade people to do the right thing and to give them the perspective of a judge who's been serving on the Superior Court for many, many years and has seen lots of cases and lots of unfoldings of scenarios so that he knows what he's talking about. And so I very strongly favor the possibility of mediation. Binding arbitration depends on who the arbitrator is, right?
Right.
I'll give you an example. You have binding arbitration with Kaiser. And you know what Kaiser does? They practically have the brother-in-law of the CEO of the company doing the arbitrating. And because of our lovely current U.S. Supreme Court, they're able sometimes to get away with that. So with arbitration or with appraisal, what you want to make sure of is that you want to know who the appraiser or the arbitrator is. The best way for that person to be selected is for each side to pick one individual and for those two individuals to select the arbitrator. That way you maximize the likelihood of an objective, experienced arbitrator handling the matter. Some policies, and sometimes you're required to go to arbitration or appraisal, and the rules that I'm just mentioning are the ones that you should adhere to when you do that. Or people can call me. I'll give them free advice about stuff like that because it's a big deal.
And we will mention as we conclude how folks can get a hold of you. But first, Ray, many times someone will be hesitant to go forward with the lawsuit. They'll avoid going that route because they feel it'll make the whole claims process take longer.
Right.
Should a homeowner avoid suing their insurance company?
Well, if you can avoid doing that and you can get what they owe you, yes, absolutely. Filing a lawsuit is not the same thing as litigating the case. Often, when you file a lawsuit, the other side has 30 days to respond, and it goes on for a very short period in time. I'm not talking about getting into full-on discovery, getting into law and motion for summary judgment motions on partial summary judgment motions. I'm not talking about hiring expert witnesses and dragging the thing out for 3 years and plus an appeal. I'm not talking about that at all. I'm talking about ratcheting the discussion up from the point of the Mississippi claims adjuster. I shouldn't disparage Mississippi. There are many very fine insurance experts in the state of Mississippi, but I use that because they have very different costs and expenses in Mississippi than they do in California. Mm-hmm. So my apologies to my friends in Mississippi for sounding like I'm disparaging them. But the point is that you want to make sure that you have a thorough understanding of what the difference is between filing a lawsuit and litigating the claim for the next few years. You don't necessarily have to do that. If anything, you will shorten the time it takes to settle a case by filing a lawsuit, as long as your allegations in the lawsuit are not exaggerated and are correct.
Right. We like to end our chats on CareyBrosPros by asking our guests to share their 3 points for success. Can you give us 3 tips for our pro listeners?
You don't want 30, huh? Just 3?
We know you could give 30, but we'll start with 3. Just bait us, if you will. Tease us.
Well, the first thing I want to do is to tell you what the email address is. I guess that's one of the points. You can always send me questions if you have it to rfbourhis@gmail.com. RFB, yeah, F like Francois. Then my last name, BOURHIS @gmail.com. And if necessary, we can send you, I've written books on this subject and many articles, and we can put you on a mailing list if you want to be on one and give you tips on a continuing basis. But the other 3 points are, number one, I'm reiterating this, but don't rely on the insurance company's opinions and experts exclusively. Never do that. Number 2, watch out for underinsurance. Number 3, don't fall for Santa Claus agents and smiley claims adjusters. And that's it.
You're the best. He is our old friend, not so old, but a longtime friend, an advocate for you as a designer, as a professional, as a builder, and for your clients. We value our relationship with him. We appreciate what he and his son, Matthew, who is also an attorney, are doing. They do great work. And we encourage you to reach out to Ray and his firm Ray, we can't thank you enough for spending this time with us.
You're very welcome. It's my pleasure. And thank you for mentioning Matthew, because I'm learning slowly but surely that he knows a lot more than I do about an awful lot of things. He's a very good guy to have in my law firm.
But don't worry, if you couldn't write that all down, we post all our guest information along with more podcast topics, videos, and articles at CareyBrosPros.com.
Okay, everybody, loosen up those tool belts and relax. It's time for a quick bro tip from the Carey brothers.
The genesis of many building projects for architects, designers, and builders result from natural disasters such as a fire, flood, or other catastrophic event. More often than not, people affected by these events are suffering from tremendous loss and are not in the best position to make life-altering decisions such as rebuilding or relocating. Sadly, these people are often hounded by their insurance companies to agree to a quick settlement, and adding insult to injury, less than scrupulous so-called contractors swarm the area to take advantage of these shell-shocked, unsuspecting consumers. As a pro, you can be a much-needed advocate for these people. First, be a trusted resource by giving them the time and space that they need to make thoughtful and informed decisions. The best advice that you can offer is to tell them to proceed slowly and not to be in a hurry to settle with their insurance company. Help them pull together all the details that they need to obtain the best, most fair settlement from their insurance company. This can involve creating an as-built set of plans and a thorough list of finishes that may be used to generate a realistic cost estimate to rebuild. Be sure to include outbuildings, fencing, paths, patios, and landscaping. And don't forget every detail right down to doorknobs and door bumpers. Remind the homeowner that they don't have to settle for anything less than what they previously had, and that the devil is in the detail when it comes to getting the best settlement possible. Over the years and through several disasters, we've had the opportunity to and pleasure of helping many folks recover from a horrific, life-changing disaster. Aside from generating great work for our business and crew, they have been among the most rewarding experiences that we have had in our professional careers. Remember to remind victims of disaster to follow the 3 most important steps to recovery. Step 1 is to plan. Step 2 is to plan. And step 3 is, you guessed it, more planning.
Well, that's our podcast for today. Thanks for listening to this edition of Carey Bros Pros, the podcast for construction professionals by construction professionals. Want more? Check out CareyBrosPros.com. You'll find articles and videos to help make your business a success.